So 11th matter adjournment ಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ.
Yes. Yes, Dodra. Padi. Yes, sir. 120 BT not 2 not 34. Oh, beautiful. Great, yeah. Yes.
Because of that, he was one to frustrate and what suicide. And there is no specific reason for suicide. Complete broad was it completed in a row and waiting.
Exhibit.
Same company.
That is second complaint. First complaint dated 8/16.
Suspecting three hands with other two brown elements. My daughter has developed father other and brown. Second postmortem, death is due to the consumption of some sites who is it? How is it done? And you ask the company. Also, three, she is the landlord of the house. The actually number two went to our house and five. Say that.
Objection. Oh, appeal number one jumped bail. Why you jumped bail?
Again, according to the consumed alcohol, they did not so.
PWC is the eyewitness. Plan knocking the door of their house, inform this is committed suicide.
Don't get mentioned in the evidence. Although the postmortem report, there is no alcohol aspect. What the postmortem? Coming to the evidence after 14 pending, one child is one procedure of bigger and mobile. Mobile is said to have been lunch in the world. Also, alleges that after the government is to have it through that mobile procedures are not produced. Being said to have there are so many not exclude because
Now, what is the relationship between accused 1 and 2 of the disease?
disease.
Huh?
One
Disease, ಅಲ್ಲೇ ಒಂದು ಪ್ಯಾರಂಬರ್ ಇರ್ಬೇಕು. ಅಲ್ಲ ಎಂ ಸಂತೋಷ್ ಕುಮಾರ್ ಅಲಿಯಾಸ್ ಸಂತೋಷ್ ಸನ್ ಆಫ್ ಪಿ ಮೋಹನ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮತ್ತೆ ಅಶ್ವಿನಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ವೈಫ್ ಆಫ್ ಸೋಮನಾಥ್ ಅಂತ ಇದೆಯಲ್ಲ ಸೇಮ್ 29 years. Paramar. A1 is the Paramar. Yes, Mr. These are merit will see. Yes. ಅದೆಲ್ಲ ಆಯ್ತಲ್ಲ ಎರಡು ಆಗಿದೆ ಎರಡು ಸಲ. So complaint suspect 3 persons Ashwini, Srinivas, Santosh. Final report accused number 2 are dropped. Initial the autopsy dispersed cause of death due to asphyxia with cardiorespiratory arrest owing to the hanging. Final report it is mentioned a suicide. After lapse of 5 months, started afresh. Final report death due to the consumption of substance containing the group. 3 versions. 3 versions. ಒಂದು hanging, ಇನ್ನೊಂದು suicide, ಇನ್ನೊಂದು insecticides. Asphyxia. ಒಂದು suicide, ಇನ್ನೊಂದು asphyxia, respiratory problem. ಇನ್ನೊಂದು this pesticides. All right, both on that. And these 2 different postmortem reports. Then yes, sir. Majige, as it is 3 versions of death, 2 1 minute, sir. And these persons were bailed to the independence of the trial. Both. You will impose stringent conditions. ಎಲ್ಲ ಮಾಮೂಲಿ ರಿಕವರ್ ಮಾಡ್ತಾರೆ ನಿಮ್ಮವರು. Male granting bail, they can't escape if they are material against them. Ultimately, they have to convict it. That's all. Final report ಬೇರೆ ಹಾಕಿದಾರೆ, ಎಲ್ಲ ಮುಗ್ದೋದ್ಮೇಲೆ ಮತ್ತೆ is it your case to hang or they have given administer Set aside. Who is evidence? FSL report says you will administer. Sir, body is there, sir. No problem. Contain insect such body is there. Who done this voluntarily or this force by these people? Husband. Number 2 is the wife. Is it our case? Accused number 1 hanged. This is. Yes. 1. Whether it is proved. Where who said? Not one of the friend Prasad. If your wife and accused number 1, they had continued illicit relationship, there must be some independent evidence by adjoining owners. Wow, extrajudicial confession. Adjoining owners. Then ಬಚ್ಚಿಟ್ಕೊಂಡು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದು. Photo ತಗೊಂಡ್ಬಿಟ್ರೆ ಇಲ್ಲ ಇದಾಗೋದಿಲ್ಲ. Somebody should show the adjoining villages, adjoining houses. Say. Same auto. That's why they use same. We should not allow. Prasad, 106 on merits. Their friends were running auto, same auto by 2 persons. They have some tax. Don't know.
Same wife by 2 persons.
We only presume same auto used by these people. ಅವ್ನು ಹೋಗಿ ಬಂದಿರ್ಬೋದು, ಅದಕ್ಕೆ ತೊಗೊಂಬಂದ ಗೊತ್ತಿಲ್ಲ. Should not be same wife. No, ಆಮೇಲೆ no violation. This time will impose stringent condition, no violation. If violate, then automatic cancel. At whom? Your grandmother. You have filed. ಅದು ಮಾಡ್ಕೊಳ್ಳಿ, ಸಪರೇಟ್ ನಮ್ ಸಂಬಂಧ ಇಲ್ಲ. Sir, how can you say merely your husband died? You have an exhalation. That is the finding. We have not expressed any opinion on merits.
complete the murder of the husband, then they assume that is the reason for that. So after the actions.
One. Ah. 36. ఇంకా Mr. Majre, motive and intention was illicit relationship between 1 and 2 proved. These are all your facts and circumstances you explain. 100% is the friend. Use the auto, same auto. ಹೋಗ್ಲೇಬೇಕಲ್ಲ ಬಿಟ್ಟು ನಳಪ್ಪ ನಿಲ್ಸಿದ ಆಟ ತಗೊಂಡು ಹೋಗುತ್ತಾ ಹಾ ಸರ್ yes we'll record that the tools to file the present application under the provisions of section 389(1) Code of Procedure. The appeal admitted by this court on 22/3/2022, convicting against the input judgment of conviction order dated 25th August 2021, made in ST 8/2016. File of the Second Additional District Session Judge Kolar, convicting the accused 1 and 2 for the offense principal provisions of section 120B, 302, 201, Redway section 34 IPC, and section 325 Roman 5 as the SC/STPO Act. They stated the application that the circumstantial evidence standard of proof golden principle required to be followed facing conviction. Guilty to be shown should be fully established. The facts so established should be consistent with the hypothesis of guilt accused. And that is to say, they should not be explainable on any other hypothesis except the accused guilty. Third circumstance should be consistent and tendency. Fourth circumstance, very possible hypothesis. Fifth circumstance, there must be chain of circumstances so complete not to leave any reasonable ground for conclusion, consistent with the innocence of the accused. It is further attended that there is no incriminating evidence just as prosecution. The complaint suspected 3 persons: Ashwini, Srinivas, Santosh. Report the name of the accused number 2, Srinivas, was dropped. In the initial stage autopsy, cause of death was due to asphyxia with cardiorespiratory arrest owing to the hanging. After the investigation report filed, by the investigation final report was filed, it is mentioned in the case of suicide. After lodging complaint to SP by PW1, after lapse of 5 months, again investigation started afresh. PW26 filed final report stating death was due to consumption of some substance containing pyrethroid group of insecticide, PYRE, cannot rule out. It is further contended that there is no consistent and positive evidence regarding cause of death. When there are two versions in two different postmortems, the view which the appellant has taken into consideration. It is further contended that the inquest was held on 18/2016. Inquest was held on 18/2016 and second inquest was held on 19/2016. After the last was 6 months. There are so many various body was in the graveyard. There are so many, all those aspects are not PW contended the version of PW1 at the earlier point in time on 18/16 is altogether different. And second, contended got by name 16, age of 9 years. None after null of none about. There is a none to look after the welfare of the child. By studying third standard, Nehru school. The father of the appellant number 2, to age of 68 years, underwent surgery for urine test tract infection. Doctor also advised weeks. The appellants are the red earners of their respective family and their farmers. There are no any criminal antecedents against them. Defendants of the trial granted bail, not issues liberty granted toward the bail, not tampered any cases or eyewitnesses. How to allow the application. The state filed objections containing consideration release on bail at the pre-trial stage and post-conviction stage are different. The accused number 1 has not made out any case for his bail at this stage after his conviction, and he has jumped bail during the trial. NBW was issued after secure and after securing he was remanded judicial custody. And appellant number 2 has not made out any case. Further contended, PW1 complaint mother sincerely filed complaint stating that her son has committed suicide, based on which UDR came to be registered. Subsequently, she gave suspicious towards the conduct of appellant number 2, wife of the deceased, kept watch on her conduct and came to know the illicit relationship between the accused number 1, friend of the deceased, and appellant number 2, wife of the deceased. After a few months, he lodged complaint to the police. There was upper judicial investigation. Separate case came to register of investigation. Charge sheet filed against the appellant. It is further contended that PW1 complaint deposed about circumstances which he lodged the complaint as per Exhibit P1, having been written as per say of the father of the appellant number 2, son having committed suicide. Later, Exhibit P19, Superintendent of Police, a few months writing letter. After a few months, writing a letter, Exhibit P9 to Superintendent. He reports about conduct of the appellant number 2, observing scratch marks on the body of the deceased at the first instance. It was corroborated in the first inquest report, Exhibit P9. He identified ring MO3 belonged to the deceased. It was recovered at the instance of appellant number 1. Mother Exhibit P. It is further contended PW 1418, who are punch witness to the recovery of MO3 ring, mobile phone MO2 at the instance accused number 1. Suppose case of prosecution. PW 3, wife of the owner of the house, wherein the deceased and accused were residing as tenant. Deposed about appellant number 1, visiting the house of the deceased quite often. The date of incident about 10:30 p.m. She saw the appellant coming out of the house of the deceased. And appellant number 2, thereafter about 11:50, appellant number 2 knocking the door of their house, informed the deceased has committed suicide. Both were come outside, appellant number 1 and appellant 2. ಆಮೇಲೆ ಅವನು commit ಮಾಡ್ಕೊಂಡು suicide. She deposed the shifted visit to hospital in Nataraksha. The doctor declared not dead. It is further contended PW 20 doctor has conducted PM report of the deceased. After examination body of the deceased, reports about the cause of death. Exhibit P18 showing the cause death due to consumption of some substance containing fluoride drop of said cannot ruled out. Exhibit PW 24, FSL officer reports what his report as Exhibit P17. Further contended that based on the voluntary statement of the accused number 1, MO2, MO3 recovered at the instance accused number 1 by the IO. The learned session judge, of considering the entire material record as rightly convicted, thereby accused 1 and 2 not entitled any bail if the release flee away from justice. Thereby, in that event, it is very difficult to prosecution secure their presence receiving the sentence, not reject the application. The Prasad filed memo along with the petition filed by Srimati K. Vasagi, complainant. Who is this Srinivas? Why he become the guardian? What's actual? Avunyak party martiri. Illicit relationship ku guardian ಸಂಬಂಧ ಏನು? How he is concerned? Guardians what's actually? Section 7 ಸ್ವಲ್ಪ ಓದಿ, ಅವೆಲ್ಲ ಬರಿಬೇಕು ಬರೆದು ಬಿಡ್ತೀವಿ. What Prasad? Guardians what's between only husband and wife. ಅವರಿಬ್ರು ಸತ್ತೋದ್ರೆ ಪೇರೆಂಟ್ಸ್ ಬದುಕಿದಾಳೆ. Only can impose against the mother, not against father. Petition section 7 Guardians Works Act against the accused number 2, Srimati Lakshmi, and her father Srinivas SC. Thereby he opposed the application for grant of bail, both the appellants. Next para. Having heard the next para, okay, you have heard the learned counsel for the parties to please. Sri Nanjan Goda MR for the appellant 1 and 2, reiterating the grounds urging memorandum of appeal and the arguments made in the application, contended that there were 3 versions in the prosecution case. That the first version, complaint by complainant suspect 3 persons, Ashwini, Srinivas, Santosh. Final report filed, accused number 2 Srinivas was dropped. The initial stage of autopsy discloses the cause of death was due to asphyxia with cardiorespiratory arrest owing to the hanging. The final report, it is mentioned in the case of suicide. Lodging complaint to SP by PW1, at the lapse of 5 months. The investigation started afresh. PW26 filed final report stating death was due to consumption of some substance containing steroid group of insecticide. Cannot ruled out. No consistent positive evidence regarding cause of death. Further contended, there are two versions in two different postmortems. View, which is where the upfront has to be taken consideration. You further contended that the first inquest report conducted on 8/2016 and second inquest report inquest Panchanama conducted on 1/9/2016 after a lapse of 6 months. There are so many varies in the postmortem. Body was in the graveyard. Absolutely, there is no material against the accused. We implicate the homicide death of the deceased, and they were on bail with pendants of the proceedings, and they are only the bread earners of their respective family and their farms. There are no criminal residents. Therefore, sought to allow the application. For contrast, the Majgail Learned Council of the state, reiterating the arguments made in the objections, contended that the first accused admittedly during the pendency of the trial was granted bail. He had jumped the bail during the trial, and NBW was issued. After securing, he was remanded judicial custody. The PW1 complaint stated the son committed suicide based on the UDR case registered report filed. Subsequently, according to the accused number, the mother of the deceased kept watch on the conduct of accused number 2, the daughter-in-law, and came to know illicit relation between the accused number 1 and the accused number 2. Thereby, she lodged second complaint to the judicial police superintendent of police Kejap. Same was referred to judicial police for investigation. After investigation, the charge sheet came to file. The material record clearly depicts that accused number 1 and 2 involved the homicide death of the deceased. Thereby, they are not entitled to the discretionary relief of grant of bail, suspension sentence, and use of bail. Therefore, sought reject the application. Sri Prasad appeared for the complainant, while justifying the order passed by the trial court, contended that the complaint already filed the petition before the family court for restoration for Katada Mailan ward as a natural guardian against the accused number 2 and her father. Thereby, she is not entitled. Accused number 2 and her father.
Parents of accused number 2.
Srinivas Yaro. ಅದೇನ್ ಹೇಳಿದ್ದು accused number 2 and her father ಅಂದ್ರೆ this Lakshmi ಯಾರು? The complaint also filed the petition sought guardians right against the parents of the accused number 2. Thereby, application. Next one. Having heard the learned counsel for the parties, the undisputed fact that the in the complaint filed by the complaint, it was suspected against 3 persons. When final report filed, one accused number 2 was dropped. The initial stage, autopsy disclosed cause of death is due to asphyxia with cardiorespiratory arrest owing to the 2, after investigation final report filed, it is mentioned as suicide. 3, after lodging complaint to the SP by PW1, after lapse of 5 minutes, the investigator filed the report stating death was due to consumption of some substance containing steroid group of insecticide cannot ruled out. Stop. In view of the above, of the 3 versions, consistent and positive evidence regarding death or cause of death of the disease. Stop. It is also next. It is also not in dispute. There are 2 various. There are 2 versions, 2 different postmortems, in which the view to be in favor of the appellants as a golden rule held by this court and Supreme Court time and again. Stop. It is also not in dispute. Court first inquest conducted on 8th 2016. Second inquest was held on 1/6 2016 after lapse of 2 months, 6 months. And the postmortem reports vary when the dead body was in the graveyard. It is also not in dispute that the complaint made by the mother of the deceased initially filed stating her son committed suicide, based on which UDR came to register and report was filed accepted. Thereafter, she suspects the daughter-in-law kept watch on her conduct and came to know about the illicit relations between the accused number 1 and accused number 2. Stop. It is also not in dispute that accused number 1 and deceased were running the same auto and they were friends as admitted by the state government in part 3 of the statement of objections. Merely because he went inside the house of the deceased and came back, thereafter when she, accused number 2, being the wife, knocked the door, thereby has committed the suicide, cannot be a rule, cannot be a ground that the accused were not involved in the death of the deceased. In the absence of any oral document evidence to prove that there was illicit relationship between the accused number 1 and 2, mere suspicion by the complaint, cannot be a ground to reject the bail, the suspension sentence and reject the application of bail. Stop. It is also not in dispute during the pendency of the trial, both the accused 1 and 2 was granted bail. Of course, accused number 1 has jumped during bail and an NBW was issued, and accused number 2 has not violated any terms and conditions of the bail granted by the trial court. Stop. Taking into consideration the material facts, material on record clearly depicts that the second complaint lodged by the complainant is based on the suspicion, suspecting the fidelity of our daughter-in-law and about the illicit relation between the appellant number 1 and appellant number 2. It's a matter to be decided at the trial. At this stage, the prosecutor is not proved that they have had the accused 1 and 2 had illicit relationship and they have committed the homicide death of the deceased. The above, the material record clearly depicts that there are 2 different versions of about the death and 2 different versions about the postmortem report. Thereby, the accused are entitled the release on bail. Benefit of release on bail. Next, in view of the above, the following order. EA1. EA1 person is a bail. They are allowed The appellant 1 and 2, accused 1 and 2, hereby granted. They shall be released on bail subject to following conditions. The appellant 1 and 2 shall execute bond of rupees 1 lakh each and like sum. What is the fine amount imposed? To deposit. The accused shall deposit fine amount for the trial court. The appellant number 1, defendants of the appeal shall not indulge any criminal activities. And they should, where is he? No, the residence of plan number 1 and 2 should not leave jurisdiction of the judicial court without prior permission. Here condition ಹಾಕ್ಬೇಕಲ್ರಿ ಮತ್ತೆ ಇನ್ನೇನು ಥ್ರೆಟನ್ ಮಾಡ್ತಾನೆ ಮುಗ್ದೋಗೋಗಿದೆ. You should not indulge any criminal activities including threatening of the complainant. Shaved ಏನಕ್ಕೆ ಅವನಿಗೆ ಸಂಬಂಧ ರೀ ಅಲ್ಲ ಹಾಕಲ್ರಿ. You don't know. Condition ಅಂದ್ರೆ ಅದನ್ನೆಲ್ಲ ಹೇಳ್ತಾರೆ. Child visit ಮಾಡಿ ನಾವೇ ಹೇಳೋದು. Then you are admitting illicit relationship. Both accused 1 and 2 should not indulge in criminal activities. And accused 1 and 2 shall not involve any criminal activities. Being present appeal, yes. ಮಗುನ್ ಮುಟ್ಕೋಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು ಇವನೇ ಹುಟ್ಟದಂಗ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಆಮೇಲೆ yes 17 years ಬೆಳಗಿಂದಲ್ಲ ಏನ್ರಿ ಮಾಡ್ಬೇಕದು. ಸೊ ದಿ ಅಪಲೆಂಟ್ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. The appellant has been judicial custody more than 17 years. The court has taken pains and directed prepare paper books, and paper books is ready. But unfortunately, counsel for the appellant, unfortunately, counsel for the appellant not present, though the case was called twice. In order to give one more opportunity, the matter immediately after vacation. Yes, Kiran. What the offense? 302, 392. 302 ಇಲ್ಲ. Acquitted. Both. Much you take time. Now we have to have a meeting 3:30. We are going. Get ಟ್ರಾನ್ಸ್ಫರ್ ಇದು ಬರ್ತಾ ಇದೆಯಲ್ಲ ಇದೆ. ನೋಡಿದ್ರೇನ್ರಿ ಸಿನಾಪ್ಸಿಸು? ನಾಳೆ ಡೌಟು, ನಾಳೆ ಅಪ್ಡೇ, ನಾಳಿದ್ದು ಅಪ್ಡೇ ಎಲ್ಲ ಬೆಂಚು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಪೋಸ್ಟ್. ಆಯ್ತು, ನಾಳೆ ಹಾಕಪ್ಪ ನೋಡೋಣ. tomorrow. All right, we'll do. Yes, Subramanya. Checker. Shakir Abbas. Last time you were not there. Why? All right, come on. Why? 15 when do you want? Day after tomorrow, after vacation. You ready and ready? Second, 16 ನಲ್ಲಿ ಏನಿದು? ನಾಳೆ ಹಾಕದ? ಶೇಖರ್ after vacation. Same. ನನ್ನ place after vacation. ಆನಂದ 8 ವರ್ಷ ಡೇಟ್ ಆಫ್ ವೆಕೇಶನ್. ಅಬು CS after Niladhar 5 years after vacation. ನೋಡೋಣ ಅದಾದ್ಮೇಲೆ. ನಾಳೆ ಆಗಲ್ಲ. ನಾಳೆ ನಮ್ಗೆ 2, 3, 4 ಬೆಂಚು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ಗಳು ರಿಟ್ ಮಾಡ್ದಾಗ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅಪ್ಲೈ ಅವರ್ ಮೈಂಡ್ ಲೈಫ್ ಅಂಡ್ ಡೆತ್. ಅದು ರಿಟ್ ಹೊಡೆದಂಗ 10 ನಿಮಿಷ ಹೊಡೆಯಕ್ ಆಗಲ್ಲ. ಆದ್ರೂ ನಾವು ರಿಟ್ ಹೊಡೆದಂಗ ಹೊಡಿತಾ ಇದ್ವಿ. ನಾಳೆ ಆಗಲ್ಲ. ನಾಳಿದ್ದು ಆಫ್ ಡೇ. ನಾಳೆ ಆಫ್ ಫುಲ್. ನಾಳೆ 4-5 ಬೆಂಚ್ಗಳಿದೆ. ಈ ಕಡೆ ಆ ಕಡೆ ಎತ್ಕೊಂಡು ವಿ ಡೋಂಟ್ ನೋ. ಏನಾಗಲ್ಲ. ವೆಕೇಶನ್ ನಾಡಿದ್ದು ಆಫ್ ಡೇ ಸರ್. ನಾಳಿದ್ದು 4 ಬೆಂಚ್ ಇದೆ. ಬರೀ ಎದ್ದೋಗಿ ಬರುತ್ತೆ ಆಗುತ್ತೆ, ಏನೂ ಆಗೋದಿಲ್ಲ. ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಡೇಟ್ ಕೊಡೋದು. ನಿಮ್ದು ಕ್ಯೂ ಪ್ರಕಾರ ಬಂದ್ರೆ ನಿಮ್ದು ಬರೋದೇ ಇಲ್ಲ. ಎಲ್ಲ ನೀವಿರ್ತೀರಿ ಕ್ಯೂ. 17 ವರ್ಷ 12 ವರ್ಷ ನಾಳೆ ಡೌಟ್ ಆಯ್ತು ಹಾಕಪ್ಪ. ನಾಳೆ ಉರ್ವಿ ಹಾಕಲ್ಲ ನಿಮ್ಗೆ. 4-5 ಬೆಂಚ್ ಇದೆ. ಆಯ್ತು ಹಾಕಪ್ಪ. ಡೋಂಟ್ ಬ್ಲೇಮ್ ಅಸ್. ನಾಟ್ ನಾವು ತಗೊಳಕ್ ಆಗದೆ ಇದ್ದು ಏನು ಮಾಡ್ತಾರೆ.